Thanks for coming. We're going to get started. So, this is Viator's first MCLE. However, he's a supervisor at the Rachel Ewing Law Firm, and he's been practicing for 12 years. So he has a wealth of experience, and I'm really excited that he's doing this presentation.
Good afternoon. Thank you guys for coming out for this presentation. And this is actually my very first one, as Christina said. I don't know why it took 12 years to do it. But first of all, I'd like to thank all those that have done this over the years since we started in 2006/2007. A lot of work actually goes into making these presentations, and I just found out. So I'm glad we're doing it, and hopefully if it goes well, I'll do more. I know there are a few new attorneys here, so this presentation has been designed to be as broad as possible, so that when you are done with this presentation, you have an idea of what reasonable services actually means. Initially, when you hear about reasonable services, the first impression you have, especially if you've been doing this for quite some time, is that it applies to 2-1E, 2-1F, and 2-2 hearings. And that may be correct, because that's the area that we place the most emphasis on with respect to the kind of services that our clients receive from DCFS. But I think it has a broader application. As you can see in the first slide, reasonable services is kind of entrenched or threaded into our code, welfare institutions code, and has applications even prior to 306B and runs the entire welfare institutions code. So for services that the department provides to our clients, the reasonable standard is what is used. And reasonable services, the assessment commences when the department makes the first contact with the parents. I know it's somewhat technical, because 361.5A basically says that the parents or legal guardians will be offered reunification services. So the impression is that that is when reasonable services actually start, but that's not entirely correct. So once the department makes contact with the parents, the services have to be reasonable, and that is why the law requires the department to explore what safety measures could be put in place initially to prevent the need for detention. And that's why 319 becomes relevant and applicable. So there's a case on that point. In the Daniel G. is a 1994 case. The facts are stated herein, where the court felt it didn't have discretion to go beyond the 18th month. But the main issue for us here is where there was a dictum by the court basically saying that once the department makes contact with the families following a referral, the services have to be reasonable. The assessment has to use the reasonableness standard. I put this in here for the very technical nature of it and what we could lose if we do not mount a proper reasonable services case when we have grounds for it. Because there's this concept of forfeiture or waiver that applies when you do not do that. So though under 36626, I think it's L1, the court could review questions of termination of reunification services when you actually file an appeal when there's a termination of parental rights. But the problem with that is that if you do not preserve the issue by filing a notice of intent as required by the code when they terminate reunification services and set a 2-6, you may be putting the people that do writs on appeal in a very precarious position, because there are some case law that has come down, and 366.26 actually says that as well, that you must file a notice of intent and file the proper brief and join the issue properly. If not, the issue is waived, it becomes non-appealable. I think I didn't put the cases there, but I think it's an important point to note that you must file a notice of intent whenever they set a 2-6 after termination of reunification services. It's very important. So if it's not clear, consult a supervisor or one of the senior attorneys on that particular issue, because this is something that we need to preserve every chance we get. So with respect to reasonable services, notwithstanding it starts before the as soon as the department makes contact with the family. But the main issue is that when the case plan is being developed, it's at that point that you really have to determine whether the services being offered are reasonable and whether it is adequate. So everybody has to chime in determining whether the services being proposed for your client is adequate and whether it's designed to address the issue. So if you have a case plan that is not designed to address the issue, knowing the client you represent and knowing what they need, you must object and let the court know what the reason for your objections are. The department has the burden and the standard of proof as stated here. So under the code, the department has the burden to prove that they provided reasonable services to the client. But in practice, the way we mount our defenses, you would think that we have the obligation to prove that the department did not provide reasonable services to the client. The code sections that articulate that are stated herein, I think, is for the 2-1E and the 2-1F. The standard of proof is clear and convincing standard, which is very high. The same we have under 361C. And for the 2-2 hearing is preponderance. I think there will be another lecture to deal specifically with what happens after the 2-2 hearing. So the meaning of clear and convincing evidence. There's really no clear definition of what clear and convincing means in a way that you could put it in very clearly defined terms. So what the courts have done here is to define it as being so high as to leave no substantial doubt, but still lends itself to some level of subjectivity, or sufficiently strong to command the unhesitating assent of every reasonable mind. So you ask yourself, which mind is reasonable here? And the cases that discuss that are stated here, and I think the most important one is Alvinar, which clearly states that the standard has to be clear, convincing, and articulates the standard as already mentioned. The meaning of reasonableness. The standard we use is reasonable services, but what is the actual meaning of reasonable services? We do not know. And I try to find out a clear, bright light definition of reasonable services, and I could not. And in the case of River M, is a 1991 case, quite old, clearly says that the court was not able to make that determination as well. So that the court still has to find that reasonable efforts were made to prevent the need for removal at the dispositional hearing under 361D. And we do not challenge this enough. And the reason why I put this here is because sometimes when we get a home of parent order, we lose sight of every other finding that the court has to make. Or when we believe that we don't have a good case, we also lose sight of all the other orders the court has to make. The court really has to find that the department made reasonable efforts to prevent the need for removal. I think is an important finding, which we have to make sure that there's evidence to support that. I also put this in, the next one is under 319D, what reasonable efforts that the department made to prevent the need for detention. Usually in detention hearings, the court makes the standard orders, and quite frankly, when we argue for release, we almost take for granted that the court would find that the department made reasonable efforts. And in looking at some detention reports, we find out that the department did not make reasonable efforts. And that is underscored by the requirements under 306, which means the department has to provide reasonable services before they even contemplate detention of the children from the parents. Contents and why the case plan is important. I'm going to be brief with this, but I think it's very important because ultimately when you have a reasonable services trial, the main issue is what was the case plan, what does it contain, how was it intended to address the needs of the family, how is it narrowly tailored to each family's need, and what did the department do with respect to providing the necessary services. The department usually are the ones that are tasked with developing the case plan. But in practice, we know that we represent parents that are indigent. So we have to be very careful as to what the case plan contains, especially when they have to do services that appear to be more of duplication and which ultimately will come down to be extremely burdensome, and you find out that they did not really comply with those. Nonetheless, we have to make sure that we have a case plan that's adequate and a thorough and complete understanding of what the services that the client needs is very important. I'll give you an example. When we had clients that speak only Kiche, and the department would require them to do domestic violence, individual counseling, parenting, and a litany of services that the department believes are necessary to address the issue. The department seems to lose sight of the fact that we don't have that many teacher service providers that are able to provide the necessary services. So in providing the list, we also lose sight of the fact that there may not be services out there that would assist our clients to be in compliance with the case law. So we have to make sure that we not overburden them and make sure that any case plan we sign up for would be one that our client will be able to accomplish. There's really no exhaustive list of services out there that will guide you in the development of your case plan. But I would like us to limit the case plans to what we believe our clients can accomplish. I know from experience, sometimes the department will offer you some of parents with the expectation that you would give them this long list of case plans that ultimately would be a burden to your clients. So in proposing settlements or language, you have to recommend that you also propose a case plan that you believe is appropriate within the class. So based on the cases that have addressed reasonable services, I have been able to distill what the department has to do in providing reasonable services. So the questions you have to ask is whether the department has been able to identify the problems leading to the loss of custody, whether the social worker kept regular contact with clients, whether the social worker regularly arranged visits, whether the social worker maintained contact with parent service providers, and in the report, actually report on their participation and progress, and whether the social worker made good faith efforts to assist in areas where compliance proved difficult, and whether the social worker has demonstrated good faith effort in implementing the case plan. And these we'll use in the analysis of the cases that will follow. The scope of reasonableness. This case, KPV Superior Court just articulates everything I just mentioned about the criteria that the department will be used, the court will use in assessing whether services were provided. The services have to be perfect. This is an assessment we have to make, given that we really do not have a clear definition of what reasonable service means. So, do we have to provide perfect service? The simple answer is no. Services need not be perfect. So all the code requires is that the service be reasonable and tailored to the specific need of each family. I think the case of Iri Misako R illustrates fairly well how services need not be perfect but could be reasonable. Here we had a parent that was kind of resistant to receiving services. In addition to that, she had language difficulties. She wasn't very fluent in English. But the main problem was that the department was able to identify what she needed, knew that she needed an interpreter, so at every opportunity the department had, They had interpreters working with her in referring her to services, but she showed very strong resistance to embracing those services. So the court felt that the department had provided reasonable services, though it wasn't perfect. What do we do if the court finds no reasonable services? I think for the 2-1E and 2-1F hearing, the court has to give more reunification services and continue it for another 6 months. I think for the next lecture, I think coming up in a few weeks, there'll be a more detailed discussion as to what happens when you do such a hearing at the 18th month hearing and the court finds no reasonable services, how the matter will be handled. So the case on point here is in the AG. It's a 2017 case. This case presents several facts that are very useful in our understanding of what the department needs to do. This was a parent that was incarcerated at some point, a parent that was ultimately deported, ultimately could have had access to DIF services in Mexico, but the department did none of that. The department did not contact DIF to find out what services were available and in what areas they could assist this father. So these are the small issues, or very essential issues actually, that we have to use to determine whether those services were actually reasonable. I think in doing this research, I found out that we could, at some point, even isolate one particular service that is key to reunification services and determine whether the department actually provided the services necessary. For example, a parent that has medication compliance issues, and the department refers her to individual counseling, parenting, and other services without really referring her to a psychiatrist or a psychologist to do medication compliance or medication management assessment. So what she really needed was medication management, not parenting, not any of those services. So if the department does not tailor the services to that specific need, then the department has not provided reasonable services, notwithstanding that we have a litany of services that the parents acknowledge receiving referrals for. So, incarcerated parents. I think this topic is very important because almost like 20% of the parents we represent at some point will become incarcerated or coming incarcerated. So the department has an obligation to provide reasonable services for those parents. I think we do a wonderful job in isolating those issues and fighting the department when we can. But in order to present a very credible and compelling reunification services case, and I say this knowing that we don't have the burden, the department has the burden, but when we present our own either testimony from our clients about the services that the department did or did not provide, or we make our argument to tie the issues, we have to be mindful of the fact that the department really has to understand that the parents that are incarcerated have a lot of difficulty with compliance. So the department has an obligation to make reasonable efforts, to show good faith effort in dealing with the difficulty in compliance. Then another area that it seems that we've lost sight of is the fact that some of the services that are ordered for the clients at the dispositional hearing, especially when they're incarcerated, are not usually available at places of incarceration. And we would be encouraged to task the department with finding alternative ways to comply with those services. Like there used to be arguments or suggestions that the parents could receive written materials as an alternative way to comply with the services that are not available. But more importantly, would it be proper for the court to order services for an incarcerated parent, knowing that those services are not available at the place of incarceration, and the expectation is that 6 months after that, the parents will be judged whether they are in compliance with those services. So what do we do in that case? We have to object to those services because we know that they present serious difficulty to our clients, and we, given our obligation to be part of the team that would suggest what is appropriate, would suggest alternatives, like sending written materials or other alternative ways given the facts of the case. So that is what we have to explore instead of having our clients come back in 6 months and not be in compliance with a case plan that is not available. So in this particular case in TW1, the social worker provided a case plan, but it did not include any kind of services for the client. I think in this particular jurisdiction, they have to file the case plan with the report, but did not include a case plan for the parents. But subsequent to the dispositional hearing, the department was able to provide, 2 months after that actually, the department was able to provide referrals to the agencies without providing some kind of contact for the parents to reach them. And ultimately, it took the department actually 3 months to provide what appears to be reasonable referrals to the clients. And the court held that 3-month delay in providing proper referrals was unacceptable. The court's reasoning being that the parents have to be judged within a 6-month span, and they've lost 3 months already. So the services provided by the department in that regard is not reasonable. So the issue becomes, do we, if the department in that circumstance recommends further reunification services knowing the inadequacy of the services provided, what do we do? Do we go ahead with saying, okay, the department is recommending further reunification services and not maintain that the services were not reasonable and have the court find because the services were not reasonable? I think it will be incumbent on us to hold the department to the task that they have to accomplish, which is insist that the court find that the services were not reasonable and continue the reunification services for the next 6 months. It has a lot of advantages, which I think we'll discuss in another lecture. But the main one being that the courts cannot, will be very reluctant to terminate parental rights down the road if the courts have not found services to be reasonable at every of the review hearings. So that really makes the department more inclined to comply with the requirements of the code. So this case, Lauren Z, is a 2008 case. The reason why I put this case here is because sometimes we have scenarios where we think the department should do more, but the courts have acknowledged that the department can only do what is within their control. They cannot do what is impossible. So this client was in jail in Florida. The department did everything, reached out to the agency in jail, reached out to Children's Services equivalent in Florida, hoping to get the assistance in providing services for this incarcerated parent. But they were so inept in their response, and the reunification services were still held to be reasonable by the court. So we can use examples of what the social worker did in cases like this to give the court examples of what our social workers could have done given the similar factual situations. So even as cases are not favorable to us, we can still tap into them in our analysis of the department's obligation and how they failed to accomplish that. So this is on the incarcerated parent as well, is the case of Tonya M., the Superior Court. Here the court held the social worker was not to blame because the parents were not in jail at the time the visitation orders were made. They did not seek out visit at the time before they went to jail. And a few months after the dispositional hearing, the parents became incarcerated and there were no visits. In this case, the court felt that the social worker found out about the parents' incarceration, and as soon as the social worker found that out, the social worker also learned that their release date was so close that there was no time to order, to set up visits or provide referrals at the place of incarceration. So when the parents were released, the department offered visits, but the parents did not take advantage of that. So the court felt that the services, though imperfect, were reasonable given the circumstances. So the case of Christopher D. the Superior Court, here the court ordered the visits for the incarcerated parent to be consistent with the rules of place of incarceration, as long as it's not detrimental to the child. The detriment being either physical detriment or emotional detriment, but not the young age of the child. The social worker did not set up visits. Rather, the social worker relied on father's statement that he could be released anytime. He's going to be released soon, which is not uncommon for our clients to say. So the social worker stated that arranging visits was very difficult. The social worker did not call the jail to find out if visits are allowed and the conditions for that. The social worker did not seek out a monitor for the visit and relied on relative caregivers that does not get along with the father. The social worker spent so much time trying to fix father's phone privileges, even though the child was not verbal. And the court held that the distance should not be an excuse for not providing reasonable services, even if it's difficult. I think this case is very helpful with respect to the point that I made about using one particular aspect of the department's obligation to make and maintain a case for lack of reasonable services. Visitation is one that you could use as well. So if you have a client that is accessible to have visits, but the department did not arrange visits, we understand the importance of visits. So even if every other thing else checks out, we can still use visit as the key to a finding that the department has failed to provide reasonable services. There are so many cases on the importance of visits in the reunification scheme. Another case for incarcerated parent is the case of Maria S. It's a 2000 case. So this contemplates that the parents will begin a case plan when released from jail, and the court found that that is flawed because when the court was aware when making that order that the child will be, the client will be released into INS custody and would not be in compliance if that happens. Services are not reasonable. Services reasonable when none is identified or offered to incarcerated parents. So when a parent is incarcerated, the department has an obligation to make sure that services are identified and offered to that incarcerated parent. And calling the jail should be key to that. So in the Precious J, here the parent was incarcerated, the court orders the department not to impede parent visits when the agency places the child outside the county boundaries. This is not uncommon. They place children so far away because of difficulty getting placement within Los Angeles County, and that impedes visits. So visits is key. If the child is placed in Victorville, you have to be on the lookout for whether the department really provided reasonable services with respect to that singular aspect. So there are so many other cases on incarcerated parents. In Monica C, the social worker tasked the parent with finding the services that were available at place of incarceration. The social worker cannot do that. The case of Tracy J is a very interesting case. I'll encourage everybody to actually read that. It's very important with respect to reasonable services for mentally ill patients, but we're going to go into that in a few minutes. So in Recalvin P, reasonable services was discussed under a scenario where 361.2 applies. It's an interesting read as well. In Kevin R, the family reunification service is fundamental. Independency proceedings and visit is key part of it. So this case tells you how important visits are and why you should use that if you want to maintain no reasonable services argument. So the Brittany S. is a 1993 case. It talks about incarcerated parent 40 miles away from where the child is placed and why the department should have provided more reasonable services. In Retailer J, which is very popular, where the social worker only provided referrals that are incomplete at that, the court felt providing referrals alone was not sufficient. So in David B, this boils down to the department not really understanding what the parents need and providing the services that are required. In David B, basically, the parents needed housing, the department knew the parents needed housing, provided referrals that the parents could not read. So the department did not really accommodate the special needs of this particular parent and did not emphasize the need to obtain housing as the barrier to releasing of the child to his care. So in RETG, the reason why I put it here is because the parents have an obligation to file a new JV 140 whenever there's a need for that. And with that in the file, the department cannot claim that the parents' whereabouts are unknown, or they could not send letters or correspondence to the parents in order to provide reasonable services. So when you meet with your client at a dispositional hearing, make sure you have an updated JV 140, or for every review hearings to make sure you update that information, because it could come in handy when the department is saying that we couldn't locate the parent, and when they have the proper documentation that the department could use to make a home visit or to send correspondence. So these are cases that some of them favorable, some of them not favorable, but I think the key here is to find out what you could use within those cases to maintain a case for lack of reasonable services. A good case is in Remark Aaron, where the department did not contact the clients for 13 months out of the 17-month reunification period, and the court felt that the services were not reasonable. So it kind of dovetails into maintaining constant and reasonable contact with the parents as part of the department's obligation. So mental health cases. This is very key, this is very unique in the sense that the department has an obligation not only to refer the clients to the proper services, but also to provide the necessary accommodation for the parents to accomplish the case plan goal. So if the parents cannot read, the department has to find somebody that will help them read the document. If the parents have such mental health problems that they're not able to absorb information, the department has to refer them to specialized agencies that will really break down the issues and the services in a manner that they would understand. So the cases, the Tracy J case, the Victoria M case, all point to how the department has an obligation to accommodate the special needs of the parents. So when you have a client that has mental health problems and the department, you don't see any attempt by the department to accommodate their resistance or their reluctance or their lack of understanding as to the enormity of what they are confronted with and the need to comply with the case plan, the department has to go an extra mile to do that. So these cases tell you what the department should have done when the parents show resistance. So the fact that you read in the report that your parents told the social worker, I'm not going to do anything, there's nothing wrong with me, doesn't mean that the department should stop at that point. The department has an obligation to make good faith efforts to assist the parents where compliance proves difficult, and mental health understanding of the issues is one of those that the courts have been able to articulate here. Every case C is an interesting case. The parents, with respect to resistance, the father said he wouldn't do anything, but the court order was for him to do medication evaluation, and he went there on 3 different occasions trying to get medication evaluation done. He was told that he does not qualify. The social worker said, okay, I went there, there's nothing else to do. Still writes in the report that father has not done medication evaluation without really articulating what he or the social worker did with respect to providing father with additional referrals or actually helping father get that accomplished, knowing that it's key to reunification services. So these are interesting cases on mental health and assistance to the families for reunification purposes. Patricia W. is an interesting one as well, where even if the department believes that the forecast for reunification services is very dim. The department still has to provide reasonable services, and in that situation, actually, the department really has to do more to help the parents overcome the barriers that make reunification services difficult. So if the department articulates in the report, these are the barriers that the parents are facing, you have to look to see what the department did to overcome those barriers. So that's very important. So barriers to reunification services, already discussed that. Mark N is very important there, and Kathy G is very important, Christina L is very important. So the nature of the barriers could be a number of things. The one I mentioned was the parents saying there's nothing wrong with me, you know, leave me alone, I can take care of my kids. Or it could be not being able to read, it could be not knowing where to access services, or going there and being told that the services are not, you do not qualify. So those are the kind of barriers that we expect the department to really assist. So some of the barriers to reunification services are self-imposed. So we have to be mindful of that. So when you are counseling your client, you really have to let them know that you have a duty to comply with the case plan, but if you do not, the consequences are as follows. And if you are ordered to comply with any kind of case plan, you have to make sure that you follow through. In this case, in Romeo A, the mother was in jail, did not want to be contacted, did not want to be labeled a child abuser, and because of that, she did not visit with the child and did not encourage the social worker to visit her in jail because of that reason. So the court felt that the services were reasonable, the barrier was self-imposed. Elijah R is an interesting one also because some of the clients we represent have some kind of criminal history, and they go in and out of jail for some different reasons. So when you have a parent that has a lifelong history of going to jail, this case tells you basically that the court may factor that in if they can't stay out long enough to receive services that sometimes it becomes difficult for the department to track you when you're out or when you're in jail, especially if you get sentenced for a long time or sent out of state. So in conclusion, reasonable services is something that we really have to aggressively pursue because it's one of the most important avenues that we have to really test the case plan, whether the department has complied with it, and what our clients have done, and whether the court should give further reunification services, or whether the court should find that the department has complied with their obligation. The last case that I put in here is Robin V. The Superior Court. This was what I called an ideal client. She would write the social worker almost like once every 2 weeks, informing the social worker what's going on with respect to the services that are not available at the place of incarceration, requesting alternative materials for to be in compliance. Did everything to remain in contact with the social worker. The social worker did not reciprocate, only wrote her once, but she kept a good record of attempts to remain in contact with the social worker, and the court held that the services were not reasonable. So if we have clients that are incarcerated, we would encourage them to not only provide us with contact information when they're released or while they're still there, but also for them to maintain constant contact with the social worker, because the social worker's inability to maintain contact with a client could also be used for the department to support a claim that they've made reasonable efforts, or for us to say that the department did not comply with the obligation to maintain reasonable contact with the clients and provide the necessary services to the client. So I kind of rushed this so I can entertain some questions on the issues.
Viator, what about a situation that I know we face all the time? Say we have a client and they've been ordered visitation and the foster parent won't facilitate visitation social worker isn't facilitating visitation, and it's getting, close to the end, and essentially no quality visits have happened at all between the parent and the child. How do you suggest our attorneys address that in court?
Okay, for Lancaster, so the question was scenarios where the department is not facilitating visits, the foster parent is reluctant to assist in that regard, the parent has difficulty visiting or having the visit set up, so what do we, how do we handle that? Visit is like the most important aspect of reunification services because it has implications where if your child is under 3 and you haven't visited at all for the review period, the consequences are unknown. So it's something that the case law basically says that the department has to make sure that the visits happen. And if the foster parent is not assisting in that regard, then they're impeding reunification services, and it may be appropriate to file a motion to have the child replaced. If the department does not follow through with the visits, that's one of the situations where you have to make sure that you do not let this reasonable services question be ignored, and you make sure that the court finds appropriately that the department did not provide reasonable services. And I would encourage you to find a way to move the child.
We have a question in Lancaster.
Okay, go ahead.
What is the remedy if there's a no reasonable efforts finding at DISPO?
Yeah, the question, I hope you guys all heard that if the department finds there's no reasonable efforts finding at DISPO.
Yes, what is the remedy at that point?
Okay, the remedy would be the department's headache. We don't have any, our goal at DISPO is to find out whether the child could be returned to the care of the parents with reasonable services being put in place, like safety measures. So if the court finds that the department has not done what they are required to do, the implication, I believe, for the department will be a funding issue, because the court has to make findings about reasonable efforts and reasonable services at every review hearing, and it affects the department's funding that they receive from the federal government.
Thank you.
Yeah.
Is there a benefit to making a record for no reasonable services when there's a continued FR recommendation?
Yes. The court has to find whether the department provided reasonable services, notwithstanding the department's recommendation for further FR. I think the two issues are mutually exclusive. But I think what the temptation we have, given our caseload and everything that we do, is to kind of let it slide. Since they're giving you more time, you now encourage your client, you're getting more time. This is your opportunity to really come through and deliver. But I think we should not do that, because these are important findings that have huge implications down the road. So there are some cases where you wish you had the court find that the department did not provide reasonable services. So I think we should stop that.
So building off of that question, we have a lot of new bench officers, and I've personally been asked, okay, counsel, so why do you care? Why are you asking me to make this no reasonable services finding when your client's going to be getting family reunification services anyway? So do you have any suggestions as to what we can say to educate the new bench officers as to why this is so important and why it matters?
Yes, the bench officers are not ignorant. They know what they want to do. They want to be in the good graces of the department, and I believe in their training, they've been told that it has financial implications. So for them to ask that particular question means that they know how the department will feel about that. So I think they're trying to push us in the other direction, where we neglect or negate our obligations to our client to protect their interests at every stage. So basically what we'll tell them is, these findings are findings that the court has to make. The department had a 6-month period where they had to provide reasonable services for the client. So the continuation of FR services stem from a different provision of the code. it does not have anything to do whether the department actually services the case the way they should. So continuation of services may be because the child is over 3 and that the parents are visiting in somewhat compliance, not because of any other consideration.
But also, if you get 3 no reasonable service findings, you can't go to adoption. So it really is important, if there's no reasonable services, to make the record and even maybe, take it up.
Yes. Okay.
Yeah, that's part of it, is if it can foreclose adoption, but what if, whatever reason, no reasonable services were either argued or lost, and we get to the 2-2, and it's the first no reasonable efforts finding that we've had, and the court says, well, there were previous reasonable services finding, we're at the 2-2, no reasonable efforts finding does not affect your ability to extend reunification services. What would your response be?
First of all, we're going to do it.
On your knees or on your feet, I don't know which one you should be doing when you're
Just as a
addressing
side
the
note, there's the training next
Yes.
week is all about 2-2 issues, and we'll discuss that specific issue.
Yeah, that's
Because there's a lot of case law about it, and there's conflicting views. So come back next week.
yeah.
I need it today, give me just one
Case where your client personally has been receiving services, but the mother and father connected case has not been, and they're so linked that it's, for example, I have a case where father did not receive any visits for 6 months, but they lived together. So if mother lived alone, she'd probably have the kids now, but because they didn't provide father with reasonable services, mother was detrimentally affected. Can you still, even though her services were fine, can you still argue with reasonable services on her behalf, even though it was mostly for the father?
On mother's behalf?
Yeah, so mother
No.
had visits, no.
No, I think we have to make sure that we keep it to the client that we represent.
I have a question about visitation with incarcerated parents. Our bench officer notoriously takes age into a factor, like it's one of the biggest factors. So if it's a young child, like 1, 2, 3, 4 even, she'll find a way to say that it's a detriment to the child to go and visit the incarcerated parent more than like once every 3 months. I mean, is there a case law specifically that states that regardless of age, if a parent is incarcerated, he or she is still entitled, unless the court finds that it's detrimental to visit at all?
Yeah, I think that's an issue that comes up quite often. I think, if I'm not mistaken, I think it's Andy J. If I'm not mistaken, I need to be sure about that. But the child being young should not be an impediment to having visits. But some parents would acknowledge that the child is too young to visit. But if the court makes an order that you do not like, or you do not believe is supported by the evidence before the court, especially when the court is not able to articulate what physical harm would come to this child if the child were to visit, or what emotional harm would come to this child under TW or TM, one of those cases, then the court would not be making the proper finding, and you have to just let the court know that the right to visit is sacred and is part of the reunification process, and the court has to articulate good reasons why the visits should not occur, and the 2 main reasons will be physical harm or emotional harm, and the court has not been able to articulate that, and you can take it up. Yes?
I know you mentioned when the court finds no reasonable services, you ask for the full 6 months. I found that most of the bench officers that I deal with in cases where they actually do make a no reasonable services finding don't give you the full 6 months. And they just usually go to the next review hearing. So how do you deal with cases like that where you're at a 2-1-E, they find no reasonable services, and because of however messed up the timeline is, the 2-1-F is less than 6 months away?
Yeah, that is somewhat kind of complicated, because I know some 2-1-Es almost like last till the 18th month hearing, and then the next, so it becomes almost like 24th month hearing, and the question is, can the court go beyond the 24 months? But if you have a 2-1E hearing, based on the question, the way I understand it, and there's still a 6-month period before it gets to the 24-month time limit, the court must give you the full 6 months, because what the client lost was not 2 months. It was no reasonable services for the review period, which was 6 months. So the court has to give you that full 6 months. You make your objection, you take it up on appeal. Yes.
What about the situation, how would you advise us to proceed when both parents are offered FR at DISPO, so it's removal from both parents? The department sort of piggybacking off of the question earlier, the department offers reasonable services to mom and recommends home parent mother at the 2-1E, but did nothing for father. And you're trying to challenge the reasonable services to father at that point, and judges push back and say, well, it's enhancement services. It's fine anyways, it doesn't matter.
Yeah, I think it's a question of timing. When you read the report and you've been able to identify no reasonable services case in the report, you really have to let the court know before the court makes those findings. When the court says, do you have any objection to the court releasing the child to the care of the mother and the recommendation for enhancement services, you have to let the court know that you want to set it for a contest because services to your client for the review period was not reasonable. So I think that kind of clarity would help the court know that you are setting it for a particular purpose and the grounds for that. I don't think a bench officer that really knows what they're doing would say, well, you don't have the right to set it for a contest because we're releasing to the mother. They'll go ahead and release to mom and set your own issue for lack of reasonable services.
And so then if you win that contest, is the next hearing both a 364 and a 2-1F for the child?
I would say yes, because you cannot, there's no other finding that the court could make when they did not properly service the case, because the goal is to unify with any parent that was provided a case plan. So I would say yes, 364 to 1F.
So, I'm sorry, was the father given FR or enhancement?
Well, yeah, at DISPO it was removal from both parents, FR to both parents, but come to 1E, their way of getting around a no reasonable efforts or services finding for one parent is to recommend HOP for the other parent.
Okay.
Does that make sense?
I'm going to kick it to Ms. Morley.
No, I'm just wondering, because please collectively correct me if I'm wrong, but the case that created the enhancement services, I think it's Pedro Z. I think it was a DISPO finding. So the question that I raise is when you're at a 2-1E or a 2-1F, and the court has ordered reunification for both parents at the prior hearing, I don't think you automatically lose, because the reason why your client is not in a position for it to be home of parents is because of the failure of the department. I had a similar argument 3 weeks ago in front of Kessler in Lancaster, where the court ordered HOP to father and a no reasonable efforts finding as to our client, the mom, and continued to order reunification. And I do believe, and I'm shocked that Kessler made the right move. She did not. Yeah, she did. And I think that was correct. She continued reunification for our client because of the no reasonable. She did not, and I would argue, and please correct me if I'm wrong, Pedro C is a limited hearing. It's a DISPO finding. It's not a status review finding. Shannon, what were you going to say?
It was something completely different than that. My question was going to be, when you mentioned saying the 2-1 hearing for a contest, are we asking for anything when we set that contest?
Yes. Okay, I think this is an important question here. When you set a hearing, I think you have to articulate the grounds for that so that the court knows that you have issues with the services provided. And I take it for granted that you would ask for Title 20 and the social worker to be on call. Most bench officers would do that, without you even asking for that to be the case. So I believe you have to really articulate that you're joining issues with respect to services.
When it comes to visitation, I guess we talked about the department or the foster parent. What if the situation is the child doesn't want to visit? What's the department's responsibility or burden there to ensure that visitation still happens?
Yeah, with respect to that, that's a kind of difficult fact situation because I've heard minors attorney tell their client, well, the court ordered visit for you, but you don't have to get into the dam when it shows up. Yeah, well, the department has, that's a barrier now. So the question is, what did the department do to overcome that? Did they recommend counseling for the child? Did they recommend conjoint counseling for the child? Did they recommend therapeutic visits between the father and the child? So you really have to expand your options here. And then as the social worker, why didn't you explore any of these prior to concluding that the visits are impossible to accomplish? Any other? Okay, thank you guys.
Everyone could please fill out eval forms.
Can you do it quickly because that's